not clear it. Now, those people who are handling the port activities, the demurrage and detention charges which came in, and that this problem did not resolve for 3 months. And 3 months means that it's a huge amount which you're talking about. I mean, huge amounts piled up. Now, shipping companies are mostly, not national companies, but they are foreign companies who are coming in. Then the port handlers are there who are Pakistani, but they're companies. Now it is there because they have a contract of 25 years. I'm just giving you this case, which I've been fighting and I've been doing this and we have been successful to an extent, but not to the extent. Now, one is to understand this, that cargoes are coming in and going out. And they're not staying there. Maybe a few of them for 8 days, 10 days, but 3, 4 days and they clear and they got their usual payments. Now, 3 months in a row, if the container is lying there, they want to charge the 3 months, 3 month long detention and demurrage charges. Government has agreed to as to waive off this, but these people are not agreeing to this. Now, is there a mediation can be done with these people? Because in many of the cases, it's still 1,000, 1,500 containers are lying at the port. Shipping companies are telling me, they came to me and they said, we will omit Karachi from our destinations because containers are not your property. We want those containers, empty containers back, but we didn't have the foreign exchange. So, I mean, there was a cumbersome kind of a situation. I think if you can do the mediation between those people who imported those goods, it's none of their fault. Government didn't have any foreign exchange, but they occupied. This is a windfall for the shipping lines. This is a windfall for those who are handling the port activities. But they never had this chance to do it. So what I'm saying is that this is a ripe case for a nationwide mediation, that all those people who have suffered, who have imported goods, they're lying there, but they're asked to pay huge charges of the demurrage and detention. I don't know whether kindly think about it. So many justices are sitting here. We are approaching the government. Nothing is happening. But this is one of the case study. You can do this. That what can be done in this regard. So this I really wanted to tell you. And then, sir, common man facing the problem. I don't know, but in Pakistan, if you go to the court, you're very right that it takes 25 years, may take more than that, and 20 years. But in mediation, is there, when somebody comes in and answer those things, when Justice Saab comes and speak, I would like him to answer that. What is the fixed days for this? Are there any timelines when you do the mediation and give your verdict? And then, like you said, that your mediation judgment would be rule of court at the end of the day when you register that. But during the mediation, yeah, when I'm sitting and I've got a dispute with some other party, I know that where the things are going. If I withdraw in between, what will be the case in that scenario? Because then there'll be no mediation award, would not be there, because it will not be a complete exercise which is taking place. So that was there. Those were the things which I had to answer, and it is very good that it is good with the. Can family disputes also be the part of this? Because there are many family disputes. People get separated, brothers get separated, big companies are there, and we unfortunately in our system we don't have initially we don't have from right from the day one, we don't have any share certificates or share like kind of a thing. The person is working, the brother is working, he buys things, and it's there in his name. All four brothers or three brothers are the partners. But in the end of the day, if you look at when you do the mediation, I've done this mediation many a times in family disputes and all those things. What happens is that one brother holds much of the cake, and then he denies and he says that no, because I was working there, so I should get this. So this goes on and go on. So there are many similar kind of problems which are there. And I definitely feel that this is a step in the right direction. We at Trade Development Authority of Pakistan, we got many of the things which can go to mediation. You will definitely recommend that. But before this, I recommend the government of Pakistan to see that we fully recognize this mediation process. If it is an international process, if the Turkey has resolved so many cases and 3 million cases in last 10 years, and if UK has recovered about, they've cleared cases of so many billions of pounds, I think this is the time that Pakistan should get this kind of an organization recognized fully. And I support this fully. And I think that chambers, which I represent, Karachi Chamber, and associations which are there, the industrial associations, all the chambers, I think they would support you. And I wish you all the best. That what you're doing is in the interest of Pakistan, in the interest of industry. And at this point in time, everybody's, fighting among themselves because things are very bad. Economically, we are passing through the worst crisis ever in the history of Pakistan. So, things are not moving fast. Our export is retarding. Imports, we have stopped them, but they're becoming expensive. So many other things are happening which are not in the interest of Pakistan. And if you are talking about default and all those things, IMF, we can't get them signed. Friendly countries are not supporting. So things are very bad in Pakistan. Let's pray and hope that Pakistan would come out of this. Pakistan has come out of these kind of circumstances in the past. Inshallah, this time also we'll do it. I wish you all the best and good luck. And thank you very much for inviting. I had so many other questions, but I think that time is there. So I would conclude this while thanking the Musalia and Shahzar Ilahi and all the colleagues and everybody who's behind this. Thank you very much.
Thank you very much, sir. Your points are very well noted, and we hope that the honorable judges who come to address the forum after this will address some of those points. I would now like to hand over the floor to somebody in Turkey who has managed to establish a dispute resolution center within the TOB, within Turkey's Chamber of Commerce. No dispute or very little disputes from TOB actually go to the court. They're resolved in TOB Ayum. We have with us Dr. Onur Yoksel, who's, of course, a mediator, but also a conflict management specialist. He is the general manager at TOB Ayum, and he was one of our hosts when we took the delegation from Pakistan. And the systems, the kind of monitoring and evaluation, the digital case management systems that they've managed to develop in Turkey are state-of-the-art. So I'd like, in particular, Dr. Yoksel, for you to also talk about the possibility or how Turkey mediates cases between the industry and its regulators. Thank you very much. Dr. Onur, the floor is yours.
Thank you. Thank you so much. I'd like to thank everyone to invite me to this special event. I'd like to share my screen. Doctor, may I share my screen? I have PowerPoint.
We are giving you you have the rights now. You can share it now.
Okay, I got it. Thank you. Again, thank you so much for inviting me to this special event, and I congratulate you to opening new Dispute Resolution Center in Pakistan. So I'm very glad to be here with you. I'm the General Manager of TOB Ayum Mediation and Dispute Resolution Center. TOB Ayum, I have some contents here for like 10 or 15 minutes. I'm going to talk about a little bit mediation and mediation plays in business world disputes. Because as a TOB Ayum, we focus on the business disputes in Turkey and in Europe as well. Definition of mediation in commercial contracts, which is very important to us to resolve the commercial disputes, and importance TOB Ayum as a mediation arbitration center in Turkey. So what is the mediation? As you all know, it is voluntary process, and we use this process in Turkey very efficiently. So mediation is kind of new. It started 2013 in Turkey. So after that, we built a very good, efficient system in Turkey. So as you know, it is a crucial point for parties' interest to stand out during the dispute resolution. As a dispute resolution center, we only focus on the parties' interest. Other than we don't use any law in mediation process. So it is interest-based negotiations in our center. So what we do as a center, we provide preparation, private meetings, planning the process, and negotiations. So this is the process that our mediators, panelists, arbitrators must use this mediation process. Preparation is when we give any case to our mediator or arbitrator, they have to do preparation stage. Preparation stage must be very efficient, then go to private meetings. In the private meetings, mediators or arbitrators collect the efficient data from the parties. That's why we put the planning process between planning process to preparation stage. So we collect the data, actually mediators or arbitrators collect the data and decide how they're going to lead the process. And planning the process is kind of, excuse me, is kind of negotiation to negotiation or before negotiation. So in the planning process, after getting essential data from the parties, the mediator or arbitrator makes plans for the negotiation process. Where is going to be, when is going to be, who are going to attend the negotiation process. So this planning process is important, but as a mediation and arbitration center, we do physically, other than video conference or other than cell phones or something like that. What is the mediator? We look mediator as a register mediation registry. Our mediators must be registered in Ministry of Justice Department system. And we work with the mediators who are expert in their field, commercial, sport, or energy, whatever, but they must be experts in their field. And then we also do reliable, impartial, can protect information, very secure system we use in TOBB. The secure system is very important for the parties to trust us or to bring their commercial cases. So if you cannot provide a secure system, mediation is not possible, especially in Turkey and Europe. So these are advantages of mediation in the business world. As I mentioned, we provide confidentiality. Confidentiality is one of the most important advantage of mediation and arbitration. Otherwise, they don't trust you. They don't trust you as a center. They don't trust you as a mediator or arbitrator. The process, as I mentioned, the process must be very efficient for all parties and mediators as well. It is very economic than judicial part. When you do mediation and then when you sign a mediation contract, it becomes the court order. So it is important our companies to come to mediation and then solve their dispute and then take their court order, then they don't need to go to court again. So we do also analysis as an advisor. So our mediators and arbitrators do analysis part for commercial negotiations. This analysis, we also risk preventions for the future. It is very important to provide risk analysis to our old partners. And we use the negotiation techniques, especially advanced negotiation techniques for our parties. Otherwise, if you don't negotiate, we cannot talk about mediation then. We don't believe it. Because without negotiation, it's like bargain. You need to know, especially mediators, and as a center, you have to know advanced negotiation techniques, and then you can lead the negotiation process. It's very important to us. What we do in TOBIUM is a commercial dispute resolution center. Commercial disputes is very important to us. like administrative law, cooperative companies, contracts. Labor dispute is very important for us because in Turkey more than 2 million, 3 million, maybe more than that, labor issues every year in Turkey. And then we are part of it to solve efficiently these disputes. And consumer dispute as well is very important for us to solve. Credit cards, consumer loans, sale through advance installments, like that, we have a lot of cases here. Elimination of joint ownership disputes. This is become more important after pandemic situation. So after pandemic situation, our cases is getting higher. And rent disputes also. Again, after the pandemic situation, rent disputes highly increased. So we saw more than 20, 40 cases maybe each week. So which is very important, crucial to us. I'd like to give you some statistic about mediation in Turkey. So as I mentioned that we started official mediation in 2013 as Turkey. So since then, we received 3 million, about 3 million cases in Turkey. So 3 million cases in Turkey, in maybe it's a record numbers, maybe in Europe. 3 million cases go to mediation, and then mediators deal with these cases. And 90% of these cases, voluntary mediation is 90% consensus. So when you go to mediation is voluntarily, so the percentage is very high. If the parties, both parties agreed to go to mediation, then consensus is increases 98%. The others, for example, mediation case requirement in commercial dispute, these are mandatory mediation. Maybe you have, maybe you don't. In 2019, commercial disputes mandatorily go to mediation, but we have about 53% success in mediation. Employee-employer disputes, which is mandatory also, since 2019, total numbers of files, about 3 million, something like that, and 60% consensus. And consumer dispute is relatively new in Turkey. We started in 2020. It became mandatory in Turkey. So we have also an accreditation system for all our mediation centers. TOBUYUM has more than 125 branches in Turkey, which is in 65 cities in Turkey. And we have employees, around like 300 employees in Turkey. And we have case managers, more than 1,000 mediators, more than 500 arbitrators. All of them is getting accreditation system here. And they are all licensed by TOBUYUM. Chambers and commodity exchange. So we used all the commercial mediation, as I mentioned, in our branches as well. So this is very important to us. I like to put it here to show you, all of you, because commercial contracts is getting very, very important for us, because when you don't do analysis of any contracts, then there is going to be disputes, definitely. So if companies or anybody don't work on the contracts very efficiently, then they go to court, as you know. So it is very important for us to do. We also use the artificial intelligence for the contracts to see the risk, any type of risk of the contracts. So we also provide our parties contract management system. Contract management system, so when we, first of all, we analyze their contracts and then see what happens in the future, and then provide some reports for parties or companies, anybody, to prevent the conflicts in the future. And then we also provide some trainings for the contract negotiations for all companies in Turkey. We also saw that common contract errors in mediation, lack of provision of dispute resolution. So it is very important that put a clause for the dispute resolution, such as you see in the screen, if any dispute arises concerning this contract, the parties will agree to try mediation in good faith to resolve such a dispute, and do so following the TOBU mediation rules. So we provide these clauses to all our companies, and then they put their this clause to their contracts. Then we started using mediation very efficiently, and with this clause, the mediation, voluntary mediation, is getting more popular in Turkey. So, importance of TOBU Center. So, our purpose is that we are International Mediation and Dispute Resolution Center. Our mission is to be one of the best international mediation and arbitration center in Turkey. We provide very teamwork, professional service, audits, and confidentiality as a mediation and arbitration center. These are very important for a center to do very good, provide very good service. So we also provide mediation, online mediation, negotiation, consulting, and training and arbitration. As I mentioned, we use the chambers of commerce in Turkey. We have more than 125 commerce and chambers in Turkey as a center. We have also a software system for mediation and arbitration. We use the software for our mediators and arbitrators and the parties. All the parties can use the system to make their appointment. We use the write their everything about the case. So this software system, it becomes is getting better, and all codes are belong to us. So we also care about information sharing, data collection, and processing methodology in commercial disputes. We use commercial theories of analysis in commercial disputes, very important to us. And international mediation centers, we use ethic codes, also international mediation rules we provide, and international negotiations as well. So I'd like to mention finally Singapore Convention. As you heard, there are 55 founding countries in the Singapore Convention, and Turkey is one of the founding country in the area. So it's also about commercial disputes, and then we are part of it, and we started getting cases in Singapore Convention, which is very important. So thank you so much for your time, and I'm very glad to be here.
Thank you very much,
Thank
Doctor.
you so much.
Thank you very much, Dr. Noor. Thank you.
You are welcome.
Thank you. So we'll be opening the floor for question and answers, because I'm sure members of the industry, special technology zones, businesses, corporates in the room have a lot of questions regarding mediation. But before I do that, I'd like to invite on stage somebody who's been a propelling force behind the institutionalization of ADR, at least in Islamabad. Honorable Justice Sardar Ijaz Isaaq Khan. Sardar Sahab is, of course, he's judge of the Honorable High Court of Islamabad, but he is also, and you might have noticed my presentation where I had mentioned the Center for Effective Dispute Resolution. Justice Sidar Jazizah Khan is also an accredited mediator of the Center for Effective Dispute Resolution, London. Sir, if you would kindly come up on stage, and then we'll, after your address, we'll open the stage for questions.
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum ji. I didn't spend much time figuring out the exact intended audience of today's gathering, but I gather this is primarily for the business community who are interested to know and to introduce what my cadre has to offer. So Shahzad told me very briefly that the businesses and industry are more interested in exploring the role of mediation with the public sector, the regulators, the taxmen. This is a very wide subject with lots of subspecialities, but I'll only talk about one of them, which is FPR, what would be perhaps one of the most significant amount of litigation that is there in the courts is in relation to tax disputes. So since I have to speak for a brief while only, I'll read out this paragraph from Deloitte Legal in 2020 about the UK. This is a paper written by them on tax mediation. Following the success of an HMRC, which is the equivalent of FPR, Her Majesty, now His Majesty's Revenue Commission. So following the success of an HMRC pilot to test the mediation process for a variety of different tax disputes, covering both direct and indirect tax issues, HMRC is firmly committed to mediation and is embedding the mediation process in its own procedures. HMRC has made a significant investment in mediation, training its own people from a variety of tax disciplines, and has over 50 internal trained mediators and externally CEDR accredited mediators. In addition, HMRC has its own dedicated resolution strategy and policy team based in London, which oversees tax mediation, policy, and the associated litigation and settlement strategy. HMRC has made alternative dispute resolution available to all taxpayers, including large businesses, SMEs, and individuals, for both direct and indirect taxes. Another note on SCC blog online in 2020 by Bhumika and Dulia is that on 13th of August 2020, this is an Indian blog, another important development came to light. The Bar Council of India wrote to the Vice Chancellors of all universities issuing LLB degrees, mandating the introduction of mediation as a compulsory subject to be taught with effect from 2020 in all 3 years and 5 years law courses. The BCI acknowledged that more and more litigants are being drawn towards mediation and are recognizing its benefits. Moreover, the BCI, again, Bar Council of India, also noted the benefits of mediation as it leads to resolution in the absence of arduous trials, and resolution comes to fruition expediently. The move has been undertaken in the hope that mediation will go a long way in reducing the staggering pendency and backlog in Indian courts. In today's time and age, ladies and gentlemen, for us to be still debating that and talking that it's a great idea, let's put it together, is really anachronistic. We are far behind the times. And we need to pursue the best, all the avenues for addressing this problem. What was mentioned earlier by FPCCI representatives and Mr. Motiwal also, that mediation is a part of the business community and they resolve their disputes through, informal mediation, what you might call it. But if that were the case, there would have been no disputes. The difference between that, what FPCCI does is, itself does, and mediation is, their process is conciliation. It has always existed in all different forms, in all organizations, but that is not mediation. Mediation, by the way, is a subspecialty of alternate dispute resolution, and we now need to recognize this as that. So coming back to the topic of, I just thought instead of making general statements, I would talk about FBR side. The income tax ordinance has section 134A in it, which is alternative dispute resolution. I read it, I have to confess, for the first time for this purpose. And I was a bit taken aback that by it is not mediation. It is not, it is just another form of arbitration really by a committee of 3 persons whose decision will be binding. Mediation is never binding until you have signed the settlement agreement. So just a few thoughts that when the FBR asks that an aggrieved person, who would be an aggrieved person in this case, probably who has received the show cause notice or has an assessment order passed against him, receives the notice, he has to apply to the board. The board will then process and decide whether or not this matter should go to ADR. And then while making that application, he also has to make an offer for deposit of tax, which would be an non-retractable offer. And the board will then appoint a committee. And there would be a panel with senior chartered accountants, all of them, and then a retired judge who is not below the rank of district and sessions judge for this purpose. This, by the design of it, is geared only towards very large disputes. When I saw this, significantly large disputes where this process to appoint a dispute-specific committee each time an aggrieved person applies is not exactly in the spirit of what we are discussing today. Then pending appeals have to be withdrawn. Of course, they can be reinstated as a condition to that. Why is that? Pending appeals could have been stayed on request, as it would happen in other mediations, non-tax ones. And then subsection 5 is very interesting, where FBR, the committee can conduct inquiry, conduct an audit, and then it would give a decision. Now, why would businessmen want to go and ask if they are otherwise not selected for audit or inquiry to have that committee appointed so that it can start conducting an audit? Then the board will, if it doesn't decide in 60 days, the board will dissolve the committee. By that time, perhaps some audit would have been carried out already. And we don't know what would happen with the committee's record. the evidence that was collected during that period, would that be admissible before the appellate authority? So all you've done is added another layer of inquiry. So when I read all this, we have to understand, coming back to that point, the nature of disputes between private persons and between the government or any statutory body or legal authority and the citizen or a business person is different. When two parties are disputing and bring a breach of contract case before a court, neither of them is entrusted by the law to enforce the law. Whereas when you're dealing with the public sector, then the public sector is at all tiers also mandated to enforce the law. So the same model doesn't exactly work here, but it works, as you can gather from the excerpt that I just read out from, that it is working. Employment disputes, regulatory disputes, all kinds of disputes are now worldwide being made subject to mediation. And why is that? And I would, with respect to, with apologies to Barrister Haya and Shazar, you don't have to beat the judiciary to justify mediation, right? There are other incidents, and since this is not a conference on reducing the judicial backlog, I won't go down that path. Just I'd say that this number of 22 million pending cases for a population of 250 million is not a big number with 3,700 judges. They are doing very well. You have a carriage that has a capacity of carrying 10 cars and you load it with 10 passengers and you load it with 1,000 passengers, it's only going to creak very slowly to its destination. So what has happened? This is not unique to our problem. Just like you have, retired judges of Supreme Court now coming forward, putting their weight behind it, takes you back 2.5 decades to when CEDR was set up, which is Center for Effective Dispute Resolution of UK, which was also at the instance of some very senior counsels, QCs, and others in the judiciary who just realized that we have to see alternatives. And 25 years later, they are here. So now we have Justice Khilji Saab, Justice Nasir Aslam Saab, Shirwani Saab, Mushir Alam Saab. They could be enjoying their retired life, but they are, spending time in the cause, for which we really appreciate that. But some of them also discovered some hidden talents. Mr. Shirwani Saab and Khilji Saab are now YouTube stars also. You should see their mock videos in mediation. They're very good. Perhaps Khilji Saab might wonder if he has been in the, if you might wonder, sir, if you have spent your life in the right calling for you, sir. So, coming back to this, of alternate dispute resolution, mediation has been the fastest growing in the last couple of decades, with very obvious successful outcomes in a lot of different cultures. And there is no reason, it's very simple. You have certain arteries, like it happens in all cities. The city center starts choking, it starts expanding, you find new arteries, so the system is choking. So it's time, high time, that we see other methods that work. The LAS was very timely. They took the lead and they trained the mediators, which was the major thing missing in here. But just to give you a brief perspective on what the High Court is currently occupied with. There's a lot of work to be done. We have had the Dispute Resolution Act of 2017. The rules were made thereunder, but nothing was happening. There were no trained mediators, no mediations, nothing. And then under the aegis of the CJP, the Chief Justice of Pakistan, he set up a committee headed by Honorable Justice Ijazul Ehsan to get going, get start talking to all the high courts and other organizations to make ADR start moving forward. So in Islamabad, an ADR committee of 3 judges of Justice Mia Gul Hassan, Aurangzeb, Justice Babar Sattar, and myself was constituted, and we started looking at it. The first problem that there are many factors, but leaving that aside, we've now been able to, with the full support of the ministry, pass the rules on ADR accreditation rules and ADR mediation eligibility rules. We're in the process of receiving applications, and an accreditation committee has been set up thereunder. There was a gap as to which code of conduct. The reason I think it wasn't happening is because there was complete uncertainty as to what would be the code that will govern mediations. If you look at all these organizations, they have rules, they have codes of conduct, enforceability. So the model wasn't, which would be the perfect model? And there were so many cooks in the kitchen. So we just shortcut the whole thing and saying that instead of making the whole thing ourselves, we just accept what the international organizations, experienced ones who have been doing it for the past so many decades and whose documents are models around the world. We said we'll accept that. If you are confirming, if your trained mediator is bound by any of those, we will accept that. So the judiciary's support behind this initiative is very much there. We inshallah intend to do as much as needs to be done, or it is within our capacity to do. But as Shahzad rightly pointed out, it is the industry that also has to see how can they leverage it. And the ecosystem is there. Your mediation settlements, settlement agreements under the law can now be enforced as a decree. But you have to work with your, let's say, constituents. And if the government officers who are sitting here, policymakers, decision makers, also need to ponder on it, do work on it as to what role mediation especially can play in these disputes. You have to again bear in mind that an assessing officer, when he has passed an order and your appeal is going before the commissioner, if you take a regulator, PTA, one of their officers would be deciding, let's say a quality of service show cause notice is issued to telecom companies and heavy fines are being imposed. What is the scope of mediation there? What is the purpose? You need to study, each of you has to study what has been done around the world and see how you can bring in those experiences in there. FPR, for instance, we were just talking about them, should get its own officers trained in as trained mediators, get 50 or so or 100 of those as trained mediators, and see there is a whole range of tax disputes that can be settled in a mediation room, not just because of good mediators, but also because the law is settled in that respect. We keep getting the same legal questions opened up over and over again. So at the FPR level, the same exercise that their advocates carry out before the High Court in tax references, effectively that legal research exercise is to be carried out by their mediation advocates to be able to advise the decision makers in FPR, their seniors, that a mediated settlement can bring you time value for money. With this brief background, I will leave the floor on this, and I thank you all for coming, and I urge especially the business leaders and the government, public sector, policy makers to actually depute some people make their dedicated core teams on mediation, first get them trained as mediators themselves, and then get going on that. Thank you very much.
Honorable Sir, thank you very much. I'd also like to take this opportunity to welcome Honorable Justice Miagul Hassan Aurangzeb Saab, who has been another driving force towards the institutionalization of alternative dispute resolution. He has particularly seen and witnessed firsthand what Turkey has been able to do, and has offered his patronage through the Islamabad High Court to institutionalize ADR in Islamabad. We are going to have two sets of question and answers. The question and answers are going to be in two different parts. There's 15 minutes and then there's another 15 minutes towards the end. So we have a lot of corporate sector members of chambers. We have the Faisalabad Chamber of Commerce and Industry. We have the Rawalpindi Chamber of Commerce and Industry, the Utter Group of Companies, Special Technology Zones. We have a lot of corporates in the room. If there are certain specific questions that you would like, and I would request the honorable judges, ADR experts in the room, Anwar Kashif Sahab, other are accredited mediators, if they would like to respond to those questions, so please answer zarur kijega. Sir, please.
Thank you very much. I'm advisor legal with Federal Tax Ombudsman, and I have a news to share with you people that in the last 6 months, we have resolved more than 1,200 cases through mediation, and this is the contribution that we did. But what is required? My question to honorable judges also.
Please continue, I'll repeat your question.
Right. So the importance which is required is that there should be the law and there should be the trained people. So with the Federal Tax Ombudsman, there was a clause, section 33, which asked for the informal dispute resolution, never invoked before, and there were no regulations available. So what we did recently, we had the regulations in place, and then the advantage with Federal Tax Ombudsman is that each of my advisor have a background of 30 years of experience working in the taxation. They've been with the federal FPR employees and all that, and that made it much easier once we trained them. Yeah, this is what we want to do. And any dispute, tax dispute, which comes to the Federal Tax Ombudsman, we assess prima facie if that can be resolved. Now, within 5 days, we have resolved more than 1,200 cases, and this is what I would like to share on any other session, the detail, how we did it. But what I really want to emphasize, it is doable. With FPR, the committee they had on alternate dispute resolution never took off. But if the resolve is there, law is there, you have trained people, which Honorable Judge rightly said earlier, yes, it is doable, and this is what I wanted to share, that we resolved more than 1,200 cases.
Thank you very much, sir. Adding to your point, it is extremely critical for these people that you're using to be trained. The Legal Aid Society, by the way, diverts around 1,500 cases almost every 6 months to the offices of the Ombudsperson. So accreditation trainings are extremely important. And like you said, it is a doable model. Thank you very much for sharing this, and we're very glad to hear this is happening. Dr. Khurram Tariq, President, Faisalabad Chamber of Commerce and Industry, please. You have a question, sir.
As you're planning to train arbitrators, and we would like to be part of that process, one thing is very important, that the classical arbitration or reconciliation process currently in vogue in most trade associations and chambers is more of a weight-based thing, and eventually it lands into a 50-50 stuff. So there is an inherent injustice in that. And in order to train associations, chambers, there has to be a built-in unlearning process. And that's very critical, because learning over a learning doesn't stay for long.
So you're absolutely right. I would like to direct the answer to this question. If any of our respected accredited international mediators would like to comment on the process of unlearning that maybe you went through during the training. First, so you absolutely rightly identified, our plan moving forward is to ask chambers to nominate people which the industry trusts, for us to train them as accredited mediators and mediation advocates. And then, but as we stand today, at least in Islamabad and Karachi, you have accredited mediators already available, so the training is not yet required. But when we come to chambers on a provincial level, we will be asking for nominations from the chambers themselves, that these are people that the industry already trusts, they're neutral, they're objective, they're willing to learn, and then we'll train them as such. But in terms of the process of unlearning itself, we witnessed this in 5 days. For a lawyer to take off the lawyer hat and wear the mediator hat is an extremely arduous process. But by the end of it, the 39 mediators available in this room were able to do it. So I'd like any one of you to please, in maybe 2 minutes, share that experience. I'd be absolutely grateful. Is there an accredited mediator in the room that might want to, sorry, Anwar Kashif sir, please. Mike, please. Anwar Kashif Saab is an accredited mediator from the Center for Effective Dispute Resolution, London, and he is a tax expert, so he handles tax mediation. So I'd like you to hear his story, please.
Basically, I just wanted to share, whenever we visit the business community, they always say that we have a mechanism of deciding the issues everywhere, whether it is a small chamber or whether it is a large chamber. But the problem is that everywhere is the third person who decided. So in mediation, it's the parties to decide. So that's the main thing which you have to learn. Because whenever we do trainings, whenever we do mediation, this is how the party can decide themselves. So this is an art by a mediator to bring the parties at that state of mind that they decide the three main things, that the relationship, the time, and the money matters for the party in case of commercial disputes. So that is very important. And learning about that, it is when you go into the process, you will get it that the mediation itself take the matters. हम जब भी बात करते हैं हम ये कहते हैं कि जी पंचायत में बात डिस्प्यूट रिजॉल्व हो जाता था, बड़े जो लोग हैं अगर हम सिंध में जाएं तो वहाँ नेक मर्द डिसाइड करते थे मैटर, बट वहाँ पे अगेन जो है ना हार्ड बर्निंग रह जाती थी. सो टू डिसाइड इट एट योर ओन, so for all practical purpose, dispute has been resolved. So this is what.
Thank you so much, sir. So the training, and for the industry in the room, or for chambers who would like to train their people as mediators or mediation advocates, a mediator training is a 40-hour training. It's a 5-day training, 8 hours per day approximately, followed by rigorous assessments in role plays. Day 3 is when we felt that the wave has shifted in favor of the lawyer or a person of authority who would otherwise be giving a decision or an option or an advice. So day 3 was when we felt now he's changed and become somebody who would actually actively listen to parties and ask them to table their options and then reach a settlement. So those 5 days are very critical. One last question before we move. We are joined by an ADR policy expert from Italy who is not only has an internationally accredited ADR center, of course, but he is with his partner in the process of designing alternative dispute resolution ecosystems in Turkey, Bolivia, Bosnia, Moldova, the Central Asian states, and he is now a partner of the Musalia International Center Arbitration and Dispute Resolution. So one last question before we move to Mr. Leonardo. Sultan Saab, please.
Responding to the question the gentleman asked, it's actually not unlearning what you've learned. It's a different hat that you wear. The 39 lawyers who've been trained in Islamabad, they are all still litigating lawyers. But as mediators, we don't unlearn what we have learned over the past years of practice as a litigator. When we wear the mediation cap, it's a different cap that we wear, and it's a different skill which we developed in those 5 days of training. So I thought I'd share my...
Thank you very much, sir. Thank you. Can we have Mr. Leonardo? Mr. Leonardo, can you hear me, please? Hi, Leo. I think you're on mute still.
Hi, can you hear me?
Hi, Leo. Welcome to the conference. This is Pakistan's first conference on mediation with the industry. You have regulators, the judiciary, Pakistan's industry, chambers, and accredited mediators in the room. The floor is yours.
Great. Thank you very much. It's a pleasure and an honor to be with you. Unfortunately, only online, but there is a reason. Actually, right now I am in Dubai, and I'm helping the government of Dubai to enhance mediation here for the public sectors and the private sectors. and I ran back from a training course that we are offering here in Dubai, a 5 days training course. What I would like to share in a few minutes my experience in the last 25 years, very short minutes, so don't worry, in creating an ecosystem, in creating what they call a market of mediation. Because before offering mediation centers, you need to have a market, you need to have a demand and a supply of services. Well, in the last decades, at least in Europe, but not only Europe, different countries, with the help of donors, they tried different models with the goal to integrate mediation in the legal system. We should remember that mediation is not really an alternative. The word, the term alternative is a little bit misleading, alternative dispute resolution. It should be used appropriate. Mediation and judiciary and the court are two faces of the same medal. I mean, they complement each other. But I mean, going back in the trial and errors that I was witness in the last few decades, there have been a lot of errors. A lot of countries failed in integrate mediation in their legal system. If the goal is not only to create a market of a few hundreds of mediation or even a few thousand mediation, if the goal, like our European directives of 2008, is to increase mediation in order to achieve a balanced relationship between mediation and judicial proceedings. So means 50-50, means every 100 cases dispute, 50 should go to mediation and 50 should go to court. The government, the judiciary, they have to think long term, and they need to nudge mediation, to nudge parties in the right direction. The only model that, at least in our countries, and again, after a lot of trial and errors, worked, is what I am very proud to say, what we call the Italian mediation model, that was, of course, adapted in different ways from different countries, where before filing a case in court, the party have to meet and attempt mediation with a professional mediators for just one meeting. And this is the demand side. The key pillar of this, our model, is two. The first one, again, in the demand side. So in some dispute types, like division of land, division of assets, inheritance cases, banking and insurance contracts, and few others, parties before going to the court needs to attend a first mediation meetings with very small fees, and basically reconnect the dialogue. And I've done thousands of these first meetings with our colleagues, and works. And what is the key is, again, reconnection of the dialogue, of the communication. So the parties are forced to meet in the same time, in the same room. I mean, in person, or of course now online. Even online works very well. And then they talk with a professional mediators, either if they want to opt out, go to the court directly, or to opt in, means to start the mediation process. Well, after 10 years that we have this model in Italy, the results are great. I mean, we have in our countries more than under 50,000 of process of mediations per year. Only our center, my center, IDEA Center, does more than 10,000 now mediation process, and 50% of parties that attend the first meeting, they decide voluntarily to opt in and to initiate the full process and pay the mediators in full. So our model is not a full mandatory. Is again is a good balance between mandatory and voluntary. So the mandatory part is only to meet the one time, and then the parties voluntarily agree to or not to go further with the full process. However, in the last few years, we noticed that, again, by working with government, the Minister of Justice and judiciaries, that what is key are the details of this law. Some countries, they changed a little bit this provision, and it doesn't work so much. For example, now we have a project in Azerbaijan in Baku. They have adopted the Italian model, but in the process of approval of the parliaments, some small details have been changed from the original legislation framework, and the results are not the same. The challenge, always the challenge of the mandatory first meetings is not being a formality where the parties or the lawyers, they go to a mediator to have a paper to go to the court. And while you need to engage the parties themselves. For this reason, we have to find, and we found again, a right balance between incentives and sanctions. We have in our legislation sanctions for the defendant, the invited party, they do not show up in the first meeting. Otherwise, they do not have any desire to show up. We have now fiscal incentives for mediation fees. This is again, and then, for example, in our provision, the parties themselves needs to be present, with or without the lawyers, but the parties themselves, they could not, delegate the lawyer, only the lawyers to be present. The presence of lawyers is very important, but the parties themselves, because it's their own decision if they want to mediate or not. So and this model works very well in different dispute types. However, my suggestion when I advise to governments is you cannot introduce this model from one day to another. It's a roadmap. You need to plan the next 3-5 years and start with maybe some dispute types which are most likely to be adapt to mediation, division of assets, family disputes, partnership dispute, company disputes. These are the ones that worked very well and then monitoring for 1 year, 2 years, and then expand these dispute types year by year. But at the same time, the other key pillar is from the supply side of the market, means to train good mediators and mediation centers. In our system, again, I'm sharing our system. In our system, all mediations are done in public and private mediation centers outside the court. So the idea, the courts are very busy and they do not have the space and the staff to deal also with mediation. So our model is that the courts or the Minister of Justice accredit mediation centers. It could be public. For example, in Italy, Chamber of Commerce are public, and in every Chamber of Commerce there is a mediation center. Every bar association, the role of lawyers is important. Every bar association has a mediation center. And then there are private mediation centers like ours, ADR Center. So while the regulator, the law set the requirements to be accredited, that are easy requirements. I mean, you have to have the space, mediation rooms, at least 2 or 3 mediation rooms. You have to have a roster of mediators to offer to the parties. And we have, again, details. Another important details is that the plaintiff choose the mediation center while the defendant cannot change the mediation center. These avoid the problem that most of the times the 2 parties, they will not agree in one mediation center. So in order to avoid someone, and again, to complicate, to point a mediation center, is one side, usually we initiate the process, the plaintiff that choose the mediation center and file a mediation request in that mediation center. We'll receive it and call the other party within 2 days, and within 20 days we set the first meetings and appoint a mediator. And again, this works very well, and the driving force from the demand side has been this pre-filing, pre-court mediation, first meetings mediation, while of course for pending cases the judges in our legislation has always the right to order mediation to the parties. It's not an invite in our jurisdiction, it's not an invite. Again, at first meetings. So the judge, after first reading, he or she can set a second hearing, maybe in 2-3 months, in 6 months, but at the same time order the party to not just wait for the second hearing, but to attempt mediation before the second hearing. So this will not have any impact on the duration of the judicial proceedings. And again, most of the times in the second hearings, the parties arrive and they have already settled the case. The demand side. The supply side is in importance, as I heard from someone in the conference, the importance of having professional mediators and professional mediation centers. Being a mediator is a profession. You need to acquire some skills, mediation skills, communication skills, and this is very important. Another piece of importance is, of course, training lawyers, judges, all the stakeholders to mediation. The lawyers, not only as mediators, but also how to represent their clients in a mediation process. What we call mediation advocacy is very important. Lawyers are usually used to represent clients only before a judge, while if they represent clients before a mediator, they have to change a strategy. And the judges like yours are very important to refer cases into mediations, to set up court-connected projects with mediation center are very important. We have some good example in Florence, in Rome, where now after a few years, after 3 years, this project started, for example, in the court of Florence, the pending cases has been cut in half of pending cases, because all the judges, the lawyers, the mediators, they sit all together, they wrote a protocol how to refer cases for pending cases to mediation centers, and again, pending cases has been reduced by 50, and other 50 have been reduced by incoming cases. And again, in this way, courts are much more efficient. And I want to highlight once again that in this system, mediation is not an alternative to a court, is not competing with a court, it just is a first step. Courts and judges are very important, but before using the limited resources of courts and judges, at least in our countries, our government said, well, before going to the court, please attempt mediation, please, sit around a table, reconnect, and with a mediator. And if you fail, the courts are still there. So I hope that our experience can be of some help in Pakistan. We have been, we hosted at different times delegation from Pakistan in Rome. A few years ago, we had a mediation tour also in the United States, and our doors in Rome, in Italy, are always open to our colleagues and friends from your country, from Pakistan. Please come back to visit us, and I really look forward to camp in Islamabad or in some cities of Pakistan, just again to share experience, to share know-how, and to be helpful. We did in the last 20 years a lot of mistakes in our policies. Now we did it right, and so you can benefit from our mistakes, and you can benefit from our model. Of course, should be adapted to your customs, to your background, to your legal system, but the key pillars are the same. As I said, I am now speaking from Dubai, a jurisdiction very different from Italy, of course, but they are benefiting from our from our experience, and we are talking with the government of Dubai to adopt the Italian model also here, step by step, not only, by the way, for the domestic dispute, but for international disputes. Having a good mediation ecosystems also not only improve the efficiency of the judiciary, but also improve the economic ecosystem. Is a needed infrastructure, a needed service to attract foreign investments and to help the local economy.
Thank you very much
for inviting me, and I am at your disposal for any
Thank you
questions.
very much, Leo. We look forward to inviting you to Pakistan and have you interact with the stakeholders here who are very actively designing the ADR system. Thank you for your time. We now slowly move towards the end of our conference, but the stage is open for another round of questions. And I would highly encourage the industry to please, if you're representing a corporate, if you're representing a chamber, please ask questions. You have accredited mediators in the room, you have honorable judges of the High Court. Please ask your questions if there are any, and the relevant stakeholders will try and answer them. All right, so with that, we now move towards the closing bit of our conference. I have particularly invited the 39 internationally accredited mediators in Islamabad, and these, by the way, are mediators who were nominated by a particular committee of the Islamabad High Court, who were lawyers in various fields. They're commercial experts, tax experts, contractual IP lawyers, some of the best that Islamabad had. And I was a part of the course that they were taking, and the kind of momentum shift that we saw from them, I would use the word unlearning, but I would use the word learning a new skill, like Sultan Saab said, learning those skills that would help them where the mediator had, where it was important. And a lot of these people have already conducted successful settlement agreements less than 3 months after they've been trained as mediators. So for the industry in the room, you'll now be seeing these mediators as well. But it is important to reach out to them for matters that have to be mediated. There is one more thing that I would like to show you. For the industry that is wondering, or chambers or special economic zones who are still wondering what a dispute resolution clause looks like, we have two clauses on the screen, one from the ICC and one from CEDA, which are model dispute resolution clauses that we would highly encourage you, at least if you're in the Islamabad jurisdiction, SIN's jurisdiction, to start adding these dispute resolution clauses in your contracts. An ecosystem now, although at a very nascent stage, exists to resolve your disputes through mediation. So we'll be looking at the disputes, and because this is part of that responsibility that lies with the chambers, that lies with the industry. Next, please. So this is the ICC standard clause. Of course, I've changed, the IMI standard clause. The parties may at any time, without prejudice to any other proceeding, seek to settle any dispute arising out of or in connection with the present contract in accordance with the International Mediation Institute's rules of mediation proceedings. ये इसलिए समझना ज़रूरी है क्योंकि the Islamabad High Court's ADR committee, like Justice Sardar Saab mentioned, has set an international standard for mediators and mediation centers and mediators to be recognized by the committee. And that standard includes the IMI standard. So if we as an ADR center are to be recognized in Islamabad, we must comply to the standards of IMI. The other clause is what was available at CEDA. No party may commence any court proceeding or arbitration in relation to any dispute arising out of this agreement until it has been attempted to settle the dispute by mediation, and either the mediation has terminated or the other party has failed to participate in the mediation, provided that the right to issue proceedings is not prejudiced by a delay. These are in the slides that are given to you in your USB, but you can always reach out to us for model dispute resolution clauses that you would like to enter into your contracts. We now move towards the certificate distribution ceremony. And of course, I would like to invite firstly Justice Miagul Hassan Aurangzeb Saab on the stage, please, because you and Sardar Saab and Babar Saab and other members of the High Court trusted the members of Islamabad's legal fraternity to be a part of those trainings, and the results, we're slowly witnessing them. So we're very grateful to you. So we request you to please come up on stage as we announce the names. So in no order of preference, Ghulam Ali Shah, advocate, internationally accredited civil and commercial mediator from Chartered Institute of Arbitrators and Arbitrators. Next up is Mr. Saeed Ahmed Zaidi Saab. Again, an internationally accredited civil and commercial mediator from the Chartered Institute of Arbitrators. Mr. Sultan Mazhar Sher Saab, internationally accredited mediator, CIAB. Mr. Abdul Rahim Bhatti Sahab, internationally accredited mediator from CIAB. Next up, Mr. Umar Farooq Saab, internationally accredited arbitrator, civil and commercial mediator from CIAB. Next up is Mr. Fayaz Ahmed Jandran, internationally accredited civil and commercial mediator from CIAB. Raja Jahazeb Akhtar Sahab, Deputy Director at the Federal Judicial Academy, internationally accredited civil and commercial mediator from CIAB. I think Raja Saab is not in the room. Madam Shireen Imran, advocate at the Supreme Court, now an internationally accredited civil and commercial mediator from CIAB. Next up, Syed M. Tayyib Shah Saab, internationally accredited civil and commercial mediator from CIAB. Next, we have the director of the Research Society of International Law, Jamal Aziz Saab, who is now an internationally accredited civil and commercial mediator. Oh, sorry. Barrister Afzal Hussain Saab, internationally accredited civil and commercial mediator from CIAB. Thank you so much, sir. Thank you. May I now invite on stage Justice Sardar Ijaz Ishaq Khan Saab to distribute some of the other certificates. Honorable sir. Barrister Sara Seerath, internationally accredited mediator from CIAB. Sardar Taimur Aslam Khan, internationally accredited civil and commercial mediator from CIAB. After Taimur Saab, we have Suhaib Sheikh Saab, internationally accredited civil and commercial mediator from CIAB. Mr. Ehsan Ali Qazi, advocate, internationally accredited civil and commercial mediator from CIAB. I think Ehsan hasn't joined us today. Ataullah Kundi Saab, internationally accredited civil and commercial mediator from CIAB. Next, we have Malik Qatada Jamal Sahab, internationally accredited civil and commercial mediator from CIAB. I think Qatada is also not in the room. Barrister Hasan Ali Raza Sahab, internationally accredited civil and commercial mediator from CIAB. Qatada, if you could also come, your name has been announced already. Mr. Saad Ahmed Rajput, internationally accredited civil and commercial mediator from CIAB. So thank you very much. Thank you. May I now invite on stage the Chief Judge of Gilgit-Baltistan, Mr. Ali Beg Saab, to kindly come on stage to distribute some of the certificates to our respected mediators, please. Barrister Momin Ali Khan Saab, internationally accredited civil and commercial mediator from CIAB. Barrister Syed Masood Raza Sahab, internationally accredited civil and commercial mediator from CIAB. Mr. Hafiz Ali Tamboli Sahab, internationally accredited civil and commercial mediator from CIM. Sir, thank you very much. बहुत बहुत शुक्रिया. May I now invite on stage Justice Mushir Alam Sahab. Mushir Sahab. Sir, Mushir Sahab has been a long-standing ally of alternative dispute resolution and was part of the initial propelling force for the institutionalization of ADR in Sindh. Tania Bezai Sahiba, internationally accredited civil and commercial mediator from CIR. Thank you. Barrister Khaliqur Zama Sahab, internationally accredited civil and commercial mediator from CIM. Madam Sadia Shehzadi Sahiba, internationally accredited civil and commercial mediator from CIR. Sir, thank you very much. May I now invite on stage Justice Athir Saeed Saab to kindly come on stage and distribute some of the certificates for us, please. Malik Qatada Jamal Sahab, I think you were left. Could you kindly come up on stage, please? Internationally accredited civil and commercial mediator from CIR. Sayyid Abdullah Anwar Sahab, internationally accredited civil and commercial mediator from CIM. After Abdullah, we have Mariam Ali Abbasi, internationally accredited civil and commercial mediator by the Chartered Institute of Arbitrators. Mr. Wasim Abid Saab, internationally accredited civil and commercial mediator by CIAB. Naseem Ahmed Shah Saab, internationally accredited civil and commercial mediator, CIAB. Thank you, he's not here. Mispal Mustafa Sahab, internationally accredited civil and commercial mediator by CIAB. Sayyid Ishtiyaq Haider Sahab. Madam Aisha Rasool from the Federal Judicial Academy. Asad Hussain Ghalib Sahab. Barrister Asad Lada Sahab. Rahman Ali Khan Sahab, internationally accredited civil and commercial mediator. There are some certificates that might be missing, but we will be distributing them at a later date. Sir, thank you very much for joining us. Bahut bahut shukriya. Ladies and gentlemen, thank you so much. This concludes the end of our conference. We hope that the industry benefited from it. We hope that the chambers benefited from it. The high tea is served. You're requested to please step outside for the high tea. Thank you.